bills, HB 2179, HB 2228, and HB 2327. And we will, subject to our time, then try to work two of the bills that we were trying to work yesterday. So would Jason, the reviser, would you please tell us what HB 2179 is about? These are hearing. Yeah. Yeah. That's right.
Just making sure. All right. Thank you, Mr. Chairman. Good afternoon, committee. As you said, Jason Thompson, Revisor's Office. You have the fairly lengthy bill brief on HB 2179, so I'll just try to hit the high points. This is the bill that prohibits fines and fees from being assessed against a juvenile or a juvenile's parents, guardian, or custodian in a case pursuant to the revised Kansas Juvenile Justice Code. The first section is a new section of law that kind of lays out that overall statement I just made. In an action under the Juvenile Offender Code, no fines, fees, costs, court expenses, reimbursements, or other financial obligations shall be ordered, assessed, or sought against a juvenile or a juvenile's parent, guardian, or custodian. After the effective date of that act, which is July 1st of 2025, any outstanding court-ordered fines or fees owed by a juvenile or their parents, etc., that were assessed in an action under the code will be discharged and shall not be collected. Second, any juvenile who is participating in immediate intervention, on probation, in a detention facility or correctional facility, or being supervised solely because of outstanding fees or fines shall be discharged. And third, a juvenile parent or guardian who is incarcerated solely because of non-payment of fines or fees shall be released from custody. The provisions of the section, I note, do not apply to restitution, so all other fines and fees except restitution. That is not covered by this act. All right, then you get into the amendatory sections, and I won't go through all of these. I'll just kind of give you key words or phrases from those statutes in case you're wondering what is carved out. Section 2 is about fingerprinting fees. Juveniles are exempted from that. Section 3 is about clerks of the district court taxing a library fee. They're exempted there. Section 4 is house arrest programs, no fees there. Section 5 is Offender Registration Act requirements. The fee for registration that you pay, those are waived for juveniles that are registered, or for offenders required to register solely because of a juvenile adjudication. So I want to use the specific words there. Section 6 is a waiver of a docket fee in certain cases that also has a fee for certain prosecutor training funds. Section 7 is a fee about a prosecuting attorney's training fund. Section 8 is a fee, $400 forensic science fee that is normally assessed is waived. Section 9 is a fee imposed by the Supreme Court for non-judicial personnel. That will not be imposed. Section 10, it gets into the Juvenile Offender Code itself. This one states that juveniles are entitled to an attorney during proceedings under the code, and the expenses for that attorney will not be assessed against the juvenile or their parent, guardian, or custodian. Section 11, also in the Juvenile Offender Code, this is the expungement statute. There's a provision that no docket fee will be charged and no other cost imposed for filing for an expungement under the Juvenile Offender Code. There's also a provision in there that I want to mention that says the court cannot deny or delay processing of an expungement petition because of unpaid court costs, fees, or restitution or financial obligations. If they choose to expunge, even though those things exist, there are provisions in that section about who would still have access to that expunged record for the purpose of collecting restitution or judgments. So you might take a look at Section 11 if you're concerned about expungement and some kind of particular provisions there about what happens if you expunge something where there are fees or restitution still due. That's all covered in Section 11. Section 12, again, still in the Juvenile Offender Code. This is the care and custody expenses for the juvenile. Current law says that those are paid from the county general fund and then can be assessed against the person who's liable to support the juvenile. The bill strikes those provisions and just provides the expenses for the care and custody of a juvenile shall not be assessed to the parent, guardian, or custodian. All right, Section 13, a couple more in the Juvenile Offender Code here. Section 13 is the one that requires offenders to pay for certain counseling and testing. Those fees will not be charged or assessed against the juvenile or their parent, guardian, or custodian. Section 14 is the requirements for pleadings under the code. You can currently have a request to require child support to be paid, and that's removed. Section 15 is still in the Juvenile Offender Code, detention criteria for juveniles. There's a provision added that says no juvenile shall be placed in a juvenile detention center solely due to non-payment of fines, fees, court costs, or restitution. Section 16 is the statute about juvenile intake and assessment. Current law says you're not denied participation or terminated unsuccessfully because of inability to pay fees, but the bill strikes that provision and instead provides no fees or costs are imposed on the juvenile for participation in immediate intervention, and juveniles shall not be denied access to those programs due to unpaid fees or costs. A couple more here in the Juvenile Offender Code of substance, and so I'll spend a second going over them. Section 17 is about incompetency of a juvenile offender to stand for trial, essentially. There's a current law provision that says parents can be ordered to pay child support, and that's removed. Section 18 is about post-adjudication orders and hearings. The cost of mental health evaluation and treatment and post-adjudication assessment tools will not be paid by the juvenile or their parent, guardian, or custodian. Section 19 is the sentencing alternatives for juvenile offenders in the Juvenile Offender Code. And there's a provision added that no financial terms or conditions shall be placed on a juvenile for participation in community-based programming, out-of-home placements, house arrest programs, drug or alcohol testing, electronic monitoring, or remote alcohol monitoring. There's also a provision that eliminates the authority to impose a fine as a sentencing option. So that's noted there. Section 20 is the statute in the Juvenile Offender Code that authorizes orders related to parents, and there's some things removed in there about charging fees to the parents. Section 21 and 22 are just technical reference change cleanups, so I won't mention anything more than that. Section 23 is the Juvenile Offender Code provision about fees and expenses for appeals. The bill provides that fees and costs of appeal, including transcripts and records, are paid from the county general fund and not assessed against the juvenile or their parent, guardian, or custodian. The last two, or a couple groupings here, 24, 25, and 26, those are just technical changes, so I mentioned that in the bill, and I'll just leave it at that. And finally, Section 27 is the statute about assessing fees for DNA testing, and there's no fee assessed for juveniles for DNA sample testing. The bill would take effect on July 1st, and I hope that covers everything at a pretty high level, but I'll be happy to answer questions.
Does the committee have any questions for Advisor? Representative Barrett.
Thank you, Mr. Chair. Just one quick clarification question. On attorney's fees, is it like with the adults where they fill out in an affidavit whether they can afford it or not, like based on their parents' financial ability to pay for an attorney, or would this just follow the rest, like for the criminal violations where no matter what, it's compensated for by the county? It looks like it's on page 13, line 6.
Right, Representative, Mr. Chairman, so we're looking at Section 10, that's KSA 38-2306, which begins on page 12 and then goes on to 13. So the current subsection A says that a juvenile is entitled to have the assistance of an attorney. Upon failure to retain one, the court shall appoint an attorney to represent the juvenile, and in current law, the expense of the appointed attorney may be assessed to the juvenile or their parent as part of the expenses of the case. And the change at the bottom of page 12 is that the court shall appoint an attorney The expense of the appointed attorney shall not be assessed to the juvenile or their parent, guardian, or custodian. From there, then you go on to page 13, and it talks about the attorneys appointed pursuant to this section, where we just said you can't assess the fee against those folks. You get a reasonable fee for your services, and it shall be paid from the county's general fund. So I believe that is all juveniles and all paid from the county fund, if I read it correctly.
Thank you. Thank you, Mr. Chair.
Any further questions? Representative Carmichael.
Thank you, Mr. Chair. I hope the chair can indulge me for 2 questions. First, Mr. Thompson, my recollection is we've seen very similar legislation in the past. I think it came out of this committee, and in fact, I believe it went across the floor and may have languished in the Senate. But my question is, first, have we seen this or something similar before? And part of that first question is, if so, are there substantial differences between this legislation and what I voted for twice last session?
Mr. Chairman, Representative, yes, you've seen this before, and no, it is not substantially different than the prior iterations.
My second question concerns the retroactivity, if you will, of this legislation. How, if at all, does it impact judgments which would have been entered or may be entered prior to the effective date?
Mr. Chairman, Representative, so back to section 1. That's subsection B that begins on line 16 of page 1. If there are outstanding court-ordered fines, fees, costs, court expenses, reimbursements, or other financial obligations that are owed that were assessed during the course of a juvenile justice code action, those will be discharged and not collected. That is retroactive from the date of the bill going back.
Mr. Chair, I'm sorry to violate my own self-imposed rule. What about the expungements? Is there retroactive application? Is this applicable to prior juvenile adjudications such that they are also eligible for expungement? I presume that they are, but I don't know.
So, Mr. Chairman and Representative, the expungement issue is handled a little bit differently. So this is just for the fines, fees, sort of financial obligations, right? Mm-hmm. Other than restitution. Restitution is actually treated separately too. But under the expungement statute, the change is only about whether you pay a fee or not. So the expungement rules don't change. You're only allowed to expunge what you can expunge under current law. You just won't have to pay a fee to do that if you adopt the bill.
Thank you. Thank you, Mr. Chair.
Representative Smith, did you have a question? Yeah.
Thanks, Mr. Chair. When you talk about juveniles, are we talking under 18?
Mr. Chairman, Representative, so the Juvenile Offender Code applies to children under 18, and if you obtain jurisdiction over them, it can last a little bit longer than that. But generally speaking, yes, those between 10 and 18, if I remember the rules right.
Thank you.
Any further questions for the revisor? Seeing none, we'll move on to the hearing. We'll first hear from proponents. Is James Bales in the audience or on WebEx? He's a Sedgwick County Public Defender, that office. Okay, if he makes an appearance, we'll come back to him. Next is Roshane Hamby, with Director of Policy and Research. Good afternoon and welcome to the committee.
Are we working now? Good afternoon, Chairman and members of the committee. Just so we're clear, my name is pronounced Roshane Hamby. I serve as the Director of Policy and Research at the American Civil Liberties Union of Kansas. I'm here on the behalf of our nonpartisan and nonprofit organization committing to safeguarding the civil liberties of everyone in Kansas. I appreciate the opportunity to provide testimony today. You will have my full written testimony. I will keep this short because I want to allow time for folk that are here to share their personal stories and for us to dive into the new evidence that was recently released by our partners at Kansas Appleseed. In short, the criminal legal system in our state imposes thousands of dollars of debt on youth. The imposition of criminal legal debt contradicts the very objectives of the Kansas juvenile criminal system. Charging fees to young individuals directly undermines the system's declared goals to enhance public safety, hold juvenile offenders accountable for their actions, and to better the capacity to live responsibly and productively within community. Fines and fees do not increase public safety. There is a lack of evidence to suggest that fines and fees deter criminal behavior among children or adults, or that they contribute to the increase in overall public safety. On the contrary, research indicates that fines and fees may have heightened the probability of a young individual committing further offenses. Therefore, fines and fees of this nature can paradoxically reduce the safety of our communities. Moreover, the burden of fines and fees can cause individuals to miss school and to miss work because of subsequent court appearances, prolonged terms of probation, and the resulting in the loss of driving privileges. And this can even lead to incarceration. These consequences detrimentally affect the child's prospects for successful reintegration and are in direct conflict with the declared objectives of the Kansas juvenile system. In short, children should not pay for government functions. Fees accumulated during interactions with the system encompass a wide range of costs, including recurring drug and alcohol tests, rental of ankle monitors, court-appointed attorneys, and even the costs associated with their own incarceration. Essentially, the state mandates that children ages 10 through 18, many of whom are too young to be employed, bear the financial burden for the fundamental operations of its system. Wealth-based punishment is a poverty tax. Fines are typically imposed without regard to the utility of the individual's ability to pay. This system creates a deeply unequal system where people who do not have the means to go on within the system cannot, and while those who have the means can willfully pay and continue to commit further crimes. While low-income offenders are caught in the cycle of debt, incarceration, interest rate, and failing credit scores. In short, right now what we have operating in Kansas is a wealth-based punishment on Kansas children's age 10 to 18. Thank you.
I think we'll take questions at the end of the proponent's testimony. And next is Brena Visosky.
Extremely close, Chairman Lewis. Brenna Visosky.
Good.
I appreciate your attempts, though.
Thank you. Thank you for
very close.
bearing with me.
Of course. Good afternoon, Chairman Lewis and members of the committee. Thank you for the opportunity to provide testimony in support of House Bill 2179 today. My name is Brenna Visosky. I'm with Kansas Appleseed, a nonprofit with a long history of unwavering commitment to advocating for the rights and well-being of children, including ending punitive youth justice practices in the state. Despite the revised Youth Justice Code, there are still parts of the youth justice system that are failing the kids it promises to help. House Bill 2179 is one vital step in building a youth justice system that is effective and achieves its goals of promoting public safety and improving the ability of youth to live more productively and responsibly in their communities. The elimination of fines and fees is an effective way of accomplishing these goals. Currently, Kansas charges more fines and fees than almost any other state, despite our counties and judicial districts having no dependency on these collected youth fines and fees. From 2022 to 2024, districts reported collecting an average of $2,300 per local jurisdiction. The largest category of fees assessed is for reimbursement of attorney fees. In fiscal year 2023, court districts in the state received $160,000 in payment for attorney fee reimbursement, despite only expending, on average, about 14% of those reimbursements. Also, on average, counties had $7 million in surplus grant funding for youth justice systems that could easily cover any amount of revenue made by youth fines and fees without impacting interventions. These unnecessary costs can turn into years-long struggles as they multiply with collection fees over time. It can take years to collect fees from youth and families, but often youth are simply unable to pay. In 2024, the entire state of Kansas assessed $394,000 in fees and collected about $345,000. However, much of that came from fines and fees assessed in previous years. The low collection rate only decreases with time, and the money that is collected makes up a negligible amount, about 0.15% of the state's $222.2 million judicial branch budget. Considering the lack of returns, the impacts of these collections present issues for more than youth and families. Collection also costs local jurisdictions money, requiring the time of police, sheriffs, public defenders, detention facilities, probation and parole officers, the DMV, state tax agencies, and court staff. Research shows the administrative costs of collections can be quite high, sometimes requiring more spending on collection efforts than the revenue those efforts bring. These costs also don't end with an individual's transition out of the youth justice system. They can follow a child into adulthood, as unpaid fines and fees are automatically treated as civil judgments against youth in Kansas, with a risk to youth and families' credit scores and their broader financial stability. Moreover, Kansas statutes authorize interest accrual on money judgments, which allows for already impractical costs to multiply long after a case has ended. The impact, unfortunately, doesn't stop at finances. Unpaid court costs may also prevent expungement of juvenile records, further limiting youth's ability to move forward with their lives. House Bill 2179 corrects these egregious fees and fines and their consequences, ensuring records for the mistakes that occurred when a person was a child don't hold them back from future success. We should follow what the data and research shows about the effectiveness of restorative justice practices and achieving true accountability. Eliminating fines and fees for justice-involved youth is a real solution. 17 other states have already passed statewide fee or fine elimination bills since 2015, and notably, 5 jurisdictions in Kansas have also done this, no longer collecting youth fees. House Bill 2179 recognizes that fines and fees simply do not work as intended. They run contrary to the stated goals of public safety and rehabilitation enshrined in Kansas law. They ineffectively and inefficiently generate limited and diminishing revenue for the state while imposing significant burdens on low-income Kansans and make existing disparities worse. I urge you to vote in favor of House Bill 2179. In doing so, you will be keeping a promise to Kansas kids that a mistake they made as a child will not set them up for a lifetime of failure, but instead will get them the support they need to thrive now and as adults. Thank you, and I can stand for questions at the appropriate time. It sounds like we're waiting until the end.
Thank you very much. Our next proponent is Tyler Williams, a private citizen. Welcome to the committee, Mr. Williams. If you would state your name before you start and then tell us what you want us to hear.
Yes, sir. Thank you, Chairman Lewis and members of the committee. My name is Tyler Williams. I am one of the original youth leaders of Progeny and Destination Innovation and a formerly adjudicated youth of the Kansas Juvenile System. So my story begins when I was 13 years old. I went into the Kansas Juvenile Justice System until about a month before my 19th birthday. Before my release, after my court processes and everything, I accrued about $1,000 in debt. When I was in facility, of course, half of my money, as soon as anything came in from family, or once I was finally able to become educated and get my first job in facility, half of income was immediately taken towards those fines and fees. Upon my release, those still continued, especially through my halfway house, but I was released off of probation too early. Upon that, I became homeless, and collection calls were made to me from the county every week to make a minimal payment, or I was to face wages garnishments and other, I'm drawing a blank.
Sanctions.
Yes, sir, thank you. My story is just, of course, one of many youth. I understand that, every situation is different, but for someone, especially so young, going into the system, coming out, trying to rehabilitate back into society, it was definitely rough. And the system was not designed, for the juvenile justice system was not designed for youth in mind. I believe that we should continue to invest in our youth, continue building on the legacy of 367, and treat kids as kids, and handle them accordingly, and end the insanity of treating youth as adults. This bill looks to end that, and I'd say please vote for it, and thank you.
I'll break my own rule. I just have one. I think it would help if you would tell us what Progeny is about. Now, are you the leader of that group?
So I am one of the original youth leaders of Progeny. We are a youth adult partnership organization, a 501c3 here in Wichita, Kansas, for the state of Kansas.
Thank you.
Thank you.
Desmond Bryant. Welcome to committee, Mr. Bryant.
Good morning, afternoon. This has been a long week, so thank y'all for having us. My name is Desmond Bryan. I am the manager with Progeny, which is a youth-adult partnership that advocates for youth affected by the system. We do that through mentorship, leadership development, and advocacy. We are dedicated to reimagining what the system looks like and want to invest more into community-based alternatives. As you see, Progeny can very well be one of those programs that allows young people and shows them a different way to think about life past their mistakes. Yet, our current system burdens our young people and our families with fines and fees, creating lasting barriers for success. A true commitment to rehabilitation means eliminating financial penalties that disproportionately impact marginalized youth and reinvest those resources into programs that offer support, education, and real second chances. Rehabilitation and accountability should be the foundation of youth justice system, but often these principles are overshadowed by oppression, debt, and incarceration. Instead of providing meaningful opportunities for young people to grow and contribute positively to their communities, the system traps them in financial burdens that stifles progress. This is why Progeny is advocating for HB 2179, a critical piece of legislation that would eliminate fines and fees for youth in Kansas. This is a step towards a more just and rehabilitative system, one that does not criminalize poverty, but instead invests in young people and their futures. As someone personally affected by fines and fees, I know the mental anguish that it can have on someone that's just trying to do better in today's world. No child should be trapped in debt from making a mistake. Many families face the impossible: pay a bill or pay a fine. That's the choice. We cannot forget about those young people. We cannot forget about the young voices. We cannot forget about the underrepresented. We cannot forget about the marginalized youth that have been ostracized simply because they made a mistake. As a kid who made a mistake, we should have the chance to learn. We should have the chance to grow. We should have the chance for leadership in today's world. Instead of support, we hand them a bill that they can't pay. Stressing families, yet time and time again, at a time when most young people just need help. And because of this, they're more likely to reoffend. This is not a partisan issue. It's about investing in youth. We have the power to create real change here. Let's pass HB 2179 and build a future that we can be proud of. A future that offers opportunities, a future that offers freedom in 2025. So I ask you today, what are we doing to invest in our young people? What are we going to do to shift the narrative? What can we do in our power right now to make tomorrow a better place? Kansas should not be balancing the back of their budget off the backs of our young people. And today, we have the opportunity to change that. Let's support HB 2179, and thank you.
Thank you, Mr. Bryant. I point out to the committee that Courtney Fontaine has submitted written testimony. She's with the Institute for Justice. And I'm asking again if James Bales is here by WebEx or otherwise. Yeah. Okay. Okay. What do we see on WebEx? What's the name? Okay. Okay. All right. All right. Well, why don't we see if she can join us then?
Good afternoon. Can everyone hear me?
We can.
Great. Well, thank you so much. My name is Nadia Mozafar. I'm a senior attorney at Juvenile Law Center and also wanted the opportunity to speak on this bill. We submit written testimony as well yesterday, but if we need anything, please feel free to let me know. But overall, Juvenile Law Center, we advocate for the rights, dignity, equity, and opportunity for youth in the child welfare and justice systems. And we really strongly support House Bill 2179. Are really grateful for your leadership in addressing this issue, especially noting that this is, not the first time that this bill has been here. So as you've heard today, the legislation prohibits fees and fines from being charged against youth in the juvenile legal system or their parents or guardians, but it doesn't change things like restitution obligations or fines or traffics or municipal violations. And so in addition to everything that our colleagues have shared today, Juvenile Law Center has researched and written about this topic pretty extensively and worked on it around the country. And so just wanted to provide a few lessons learned from these opportunities that we've had. And so first, fines and fees really don't make fiscal sense in a few jurisdictions that researchers have been able to find information on the revenue and how much it costs to collect the money. We're really seeing that a lot isn't being collected and it costs a lot of money to collect that small amount. So on the revenue side, as folks have stated, it's pretty obvious that kids don't have money to pay fees. We've never seen a jurisdiction that's substantially funded by juvenile system fees, and that is the same for Kansas as well. So national research has made clear that children from low-income families are much more likely to end up in the juvenile legal system. So collecting money from children and families that don't have resources or even changing our collections won't work. This just really just becomes kind of an inefficient system. And on the collection side, in more than one jurisdiction, researchers have found that juvenile fees are wasteful and inefficient because it costs too much in staff time to try to collect money from children and families who typically lack capacity to pay. In some places, states or counties are even paying more to collect than the amount that they bring in. So overall, just fiscally, not a strong practice around the country. We've also learned that fees and fines increase recidivism, so eliminating them is good for public safety. We've asked two criminologists, Alex Picaro and Wesley Jennings, to examine the impact of fines and fees on youth, and they analyzed more than 1,000 case files in Allegheny, Pennsylvania, and found that youth who had costs imposed on them had higher recidivism rates than those that did not. And this research held true even when controlling for age, race, gender, and type of offense. And then they conducted similar research in Florida and found similar results. We have also learned that fines and fees harm youth and families. Parents have reported things like choosing between groceries and paying court fees. Grandparents have, in some horrible cases, considered giving up custody of their grandchildren because court fees feel so overwhelming. Children have waived counsel or appeared in court unrepresented because they're worried about attorney's fees. And families have opted their children out of diversion programs or other programs that would be helpful to them because of the cost. In Kansas in particular, probation officers and court administrators have reported that sometimes young people don't take an offer to go to a diversion program because they have to pay up front. And so finally, we've learned that fees and fines cause unfairness in the system. The most obvious issue here is one of economic fairness, where children from wealthier families can quickly pay off fines and fees while children without access to financial resources end up lingering much longer in the justice system. So overall, eliminating juvenile fees and fines that we've seen around the country really improves the efficiency and the fairness of the juvenile legal system. It creates safer communities and will give Kansas children even greater opportunities to thrive. So we really want to thank the committee for letting us speak on this issue, especially making opportunities to testify virtually. And thank you for your time, and also available for questions at the appropriate time.
Thank you, Ms. Mozaffar. Is that
Mozafar.
close?
Thank you. Close.
Yes, thank you. Okay, do we have someone else on WebEx that would like to speak? That's it? Is there anyone else in the audience that wants to speak as a proponent? If not, we're now ready to take, yes, welcome.
How you doing? How you doing? Hold on, let me take my jacket off.
Yeah, that's fine. Thank you. Make yourself at home.
How y'all doing? My name is Adonijah Metcalf. I am also a member of Progeny. I've been a youth advocate with them since 2018, so I just kind of want to speak to my experience as well. So I want to first thank y'all, the chair and the committee, for the opportunity to speak today. I'm just here to discuss how fines and fees create unintended consequences and that weaken public safety, burdens families, and limit economic growth. And by addressing these issues, we can make our justice system more effective and our economy stronger. So the real world impact of fines and fees as far as public safety and concerns, when people can't pay fines, they face license suspensions, arrest warrants, and even jail time. This is taking law enforcement resources away from serious crimes that are being committed. The barriers to work, so someone working in a low-wage job can quickly fall into a cycle where they lose their license, can't get to work, and they end up deeper in the system. Taxpayer burdens, it costs more to jail someone for unpaid fines than the revenue these fees bring in. So as mentioned before, we're spending more trying to get the money that we're actually receiving. Where we're spending money to keep people from being productive citizens, basically. As far as the economic case, more people in the workforces, when we remove these barriers, more people can stay employed, leading to greater economic stability for families and local businesses. There's a stronger local economies. Instead of funneling money into court debts, families can spend on housing, transportation, and education, things that create more long-term economic growth. And then it's just smarter budgeting. States that have reduced reliance on fines and fees, they've saved millions in court costs, law enforcement time, and incarceration expenses. As far as closing, it's really not about being soft on crimes. It's more about being smart with the justice. So by removing these barriers, it can strengthen our workforce, reduce reduce burdens on law enforcement, and make better use of taxpayers' dollars. So I urge the community to consider reforms that make our system fairer, such as the one that we have been presenting for the past couple of years. And thank y'all for having me.
Thank you very much. Anyone else in the audience that wishes to speak as a proponent of the bill? If not, we'll now take questions from the committee. Representative Mosley.
Okay, I have a few questions, so feel free to boo me and I'll just go back into the rotation. My first question is, just to be clear, divergent, I always mess up divergent, thank you, I obviously don't know much about it. Those fees are waived in this program for young people. Then my next question is, what have you seen around the country? I'm pretty sure we're not the first state to ever get rid of these fees. What have you seen around the countries when they have done fee and fine reform?
I'm happy to start. Well, whenever. Sorry, go ahead. I'm also here for questions, if helpful.
Nadia, you take it.
I'll provide a little bit of a national perspective, but also, others please jump in. But this fees and fine reform is really having, a big moment across the country. So we've seen 25 states who have passed at least, some or all fee or fine regulation, and this is happening fee and fine elimination, and this is happening all over the country in kind of throughout geographic areas and in a very bipartisan effort. Kansas certainly would be following a growing trend of states that are realizing, a lot of the same things that my colleagues have shared today, that fee and fines are fiscally not helpful to states and that they are creating a lot of harm for young people. And it's often in getting rid of the fees and fines that states are finding that it's actually a fiscal benefit to them because they don't have to spend the money on collections.
All right, and then thank you very much for that. My next question is, how are children held accountable if we don't have fees and fines for them that puts them in debt?
Just restate your name so we know who's speaking.
My name is Desmond Bryant, and although this is an evidence-based or research behind this statement, accountability is not, especially from where I come from, placing a fee or a fine is not going to hold a young person accountable to anything. What we must do is identify a young person that's actually struggling and then impose the proper resources that are necessary to change that young person's future. Given a young person that doesn't have anything, now he has to pay $500 to get back on track. He'll never get back on track, and that is a fact. You know, and that's a personal fact. Having certain fines and fees, trying to do better at 16, okay, now I have to drop out of school. Now I have to get a job. Oh, why didn't you be successful in life? Because I had to pay a fine and fee when I was 16. Although there are certain circumstances, we can live in the 0.02% of the young people that, what about them? We have to think about the majority of the young people that are actively trying to do better. And as I stand in front of you, I am a young person that wanted to do better, and I was put on a trajectory that had the right resources for me to do better. All I wish is that as leaders, we can support this idea and interject more resources in. Accountability is in a form of mentorship for me. If we can put more of us out there that is actively trying to create change for the community, I feel like that's where we hold our young people accountable through the face-to-face interaction, and by no means will it be held by fines and fees.
And this could be a question for you as well, or anyone, but what are the how would you have benefited from not having fines and fees when you found yourself on the wrong side of the law as a young person?
I could just think about the money that I did spend, you know, trying to get my life back on track. If I could have invested that back into myself in a more positive manner, via getting a trade, via mentoring with the CEO, taking that $1,000 and actually putting it back into something productive, I think that we have to reevaluate how we're spending these fines and fees. If it's not going back into the community firsthand, then we're doing ourselves a disservice. We're doing our taxpayers a disservice. We're doing every homeowner in Kansas a disservice by not properly reallocating these fines and fees. If it's not going back into a young person's future, where is it going?
Thank you. And then this is my last question. It's probably
We're going to go on to another.
Oh, wow.
I'll come back to you.
so I guess that's the booing. Okay.
Sorry, I didn't make that clear, but Representative Butler, I believe you were next.
Thank you, Mr. Chair. And I remember this bill from last year, and I think we passed out of here, and it was a good bill. And then one of the questions I've got, and because I think the young men and women of our state and our communities and our nation really are the future, and what we need to do to prepare them for that. And so, just a question: you mentioned a couple numbers, of $500 or $1,000. I guess one of the questions I'd have is there an average fine, so a general fine that somebody gets? You walk away from something, maybe a $500 or a $1,000 fine. That'd be my first one. Then I have a follow-up if I could. And there may not be, and that's okay. I just wondered if there was.
We don't have an exact average, but I would bet that we could get that information for you. So
it was just a question, because I guess it leads into the next one. If a young man or young woman cannot pay that, and mom and dad can't pay that, what happens to that young person? What happens to them? They continue to spiral down, right? And they would move on. And I used to command 400 people, 400 men and women in a unit in the military. And if I took one of those people that would get in trouble, and I would bring them in for non-judicial adjudication and punishment, if I took money from them, it would cause them heartburn. They couldn't have money for gas to get to work. They may not have money for food for their family. And so I learned very quickly that there's other ways to do things, such as other opportunities, extracurricular kind of activities instead of money. And in doing so, that helped. And so I think this is a good bill. I hope to see it go through there.
Representative Schlingensiepen, please.
This is a question for Brenna Visotsky. I hope I got your name right. Did I hear you say earlier that that waiving fees was somehow could result from participation in restorative justice programs, or is that just something that shot up in my brain as you said something?
I think I was mentioning that we could remove fines and fees without it negatively impacting funding those kinds of programs.
Okay, because I thought, you know, to the question, what are the consequences for a youth? I mean, this bill doesn't remove restitution. So in other words, the accountability is still there. You still have to make right what you've made wrong. The other question, though, that I have in my mind that just pops up is that, you know, one of the advantages of restorative justice programs is that people have to interact with those whom they have injured in some way. And that creates a kind of mutual understanding. Example from Topeka, Kansas, where the district attorney has engaged in restorative justice practices to youth, destroyed the window of a local shop, and after a restorative justice intervention, they became the employees of said store owner for a period of time until restitution was made. And after restitution was made, he hired them because they all got on really well with each other, and there was a kind of a mutual understanding of the factors that went into that act. And so I guess I'm just kind of wondering whether waiving fees and so forth could be connected with some kind of a meaningful restorative justice intervention in which we're doing something a little more than just waiving fees, which I'm perfectly okay with. I like the bill as it is, just to be clear, but I think somehow, I somehow think the value of restorative justice is such that it really does contribute to more than just somebody rethinking things. It also creates understanding in the community and frankly creates community where there's been a kind of rupture before. So it's just a thought I'm throwing out there. Thank you.
Can I respond to that?
You may.
Thank you, Representative Chairman. Yes, I think that's very much our intention with this bill. You've heard from a lot of folks about how we hold kids accountable, and I think we're in agreement that that restorative justice piece is an actions-based consequence that's going to have more positive outcomes, the data shows, than imposing a fine or a fee to that youth. Disconnecting the monetary aspect from that would make a huge difference to Kansas youth, especially those who are low income, as mentioned, making up a significant portion of our youth justice system. So thank you for your question and also your statement.
Okay, Representative James, did you have a question?
Thank you, Mr. Chair. My only question is to the reviser, yourself, or whoever was on this board over the past few years. Did this similar bill make it out to the floor and was voted on, or did it make it out of committee, or was it never in committee?
Right, so I wasn't on the committee last year. It's my recollection, and the reviser or research can answer. So I won't opine. I'll just ask for them to tell us what happened with the bill.
Thank you, Mr. Chair. Representatives, so this was 2023 House Bill 2073. It was voted out of committee, but then it was stricken from the calendar by Rule 1507, which means that it didn't make it above the line on general orders during turnaround week. And so then it was, it essentially died on the House floor, and so it wasn't voted on in the House.
Representative Martinez, did you have a question?
I have kind of a statement and a question. Thank you, Mr. Chair. And thank you all for your presentations and coming today. First of all, restorative justice, I think it's a perfect opportunity for this situation. I've been looking for somewhere to fit that in. The philosophy of restorative justice, harm, crimes, justice heals, behavior has meaning. And I think my problem with this proposal is at what point, because I asked this question before when this came to the committee, how many times do do you expect to waive fees, fines and fees? And the answer to that was as many times as it took, pretty much. So my problem was wherein that is the learning, is the lesson, you know, in terms of reducing recidivism, not committing crimes again, you know, things like that. So restorative justice is a perfect opportunity because it does create that circle of support. It allows for one to hear how their actions impacted others. It's an opportunity for restitution, really just to learn from your actions. So I think it's a perfect opportunity. I don't agree that fines and fees teach anything other than, you know, gosh, maybe I shouldn't do that again. But when your parents are paying it, then it's like you don't really feel that either, unless you have some really strong parents who are making you do some things to pay them back or whatever the case might be. But I do believe that this is an alternative, restorative justice. So if we could find a way to fit that in, I'd be all for this. Because like I said, I don't think fines or fees do anything. So I agree with that. Accountability, yes, we need accountability because you don't want to continue to create those debts for yourself or your parents. Is there, now it says people of color are disproportionately arrested, incarcerated, and charged fines and fees. Is there data that reflects this?
Thank you, Representative Martinez. If I can address some of your points before answering that question.
Okay, thank you.
So to your point, Kansas does a really good job of already including community service, restorative justice inside of the Kansas code, and that's already accounted for in the budget. So taking away fines and fees is not an either-or process, that is currently happening with juvenile in Kansas. An additional point is that it is not simply children passing on the buck to their parents. National evidence shows that 60% of families have a family total income of $20,000 or less who have kids within the juvenile system. Furthermore, in Kansas, 80% of Kansas adults who are deemed indigent, who are classified as low income, often have children that are inside of the Kansas juvenile system. So we are not looking at a body of well-to-do children. We're looking at families that are already impoverished according to Kansas income levels. To the point, your last question regarding, could you remind me your question again?
You have data that, because it says people of color are disproportionately arrested, incarcerated, and charged fines and fees. So did you have data to support that?
Yep, absolutely. Black youth, particularly in Kansas, are 6 times more likely to be detained than white youth, exposing them to more fines and fees. And that has been produced in Kansas research, and I'm happy to provide that and come and talk to you more about that in your office.
Okay, I have one more question. Okay. So I don't know if you have this data also. After paying a fine or a fee, do you have any data that reflects that the recidivism rate?
Yes, actually data shows that does not impact recidivism rates, and oftentimes, particularly in Kansas, we actually contact third parties to try and get the fines and fees because oftentimes we're unable to recoup the cost. So what we're looking at is individuals who this now impacts their credit scores when they become young adults. This now impacts civil judgments against them. So if anything, it further hinders the process to them becoming reintegrated into society.
Okay, and I realize that that's what this was about, but I guess what I meant was if a fine or a fee was a problem and then you finally paid it off, and I guess there was, well, you know what, forget it. Because I would like to know if you pay a fine or a fee and you're thinking, dang, I got that out of the way, my parent, you know, it's caused such a hardship for my parents and myself, you know, I'm not going to do that again. And that's kind of what my thought is.
I would like to think we all have that alleviation when we pay a fine or fee off, so probably.
But I guess that's not the case, right? Thank you.
All right, we're going to close as far as proponents go. We don't have any more, we don't have opponents, but we do have a neutral. Laura Bors is, Ms. Bors, are you on WebEx? No? I'd just say that Ms. Bors is from my district. She's a leader in the community. She's a lawyer, leading lawyer there. She's worked hard on juvenile justice issues, I know, and her practice involves a lot of these sorts of issues. And you might, I'd recommend that you read her neutral. It raises some, I think, issues about possible amendments that would, I don't think, substantively alter the direction we're going, but might nonetheless be something we should look at. All right, we're going to close the hearing then on HB 2179. And we're going to move on to HB 2228. If Jason would tell us about that. Thank you.
All right. Thank you again, Mr. Chairman. As you mentioned, Jason Thompson, Revisor's Office. House Bill 2228 is the bill that requires the Secretary of Corrections to assist inmates with obtaining identification and employment-related documentation prior to release from custody. This is a new section of law, and it requires the Secretary within 9 months prior to the release of an inmate to determine whether that inmate has current versions of certain documentation. If the Secretary finds that the inmate does not have a couple of items, they are required to make a reasonable effort to provide them with that documentation. And those are, there in the middle of the page, the certified copy of a birth certificate, Social Security card, or replacement Social Security card, and then either a driver's license, if they're eligible, or an identification card that's issued, one of those non-driver identification cards, if they're not eligible for a driver's license. If the Secretary finds the inmate does not have their vocational training record, their work record, their educational certifications or diplomas, current resume, then the Secretary is required to provide the inmate with those documents that they have. The Secretary is also required to coordinate with state agencies as necessary to gather these documents, and all state agencies are also directed to coordinate with the Secretary to implement this section so that all of it works together. The new section does not apply to the inmates who are going to be released to the custody of another jurisdiction, basically a warrant or detainer that would send them somewhere else. It also doesn't apply to inmates who are determined by the Secretary to be physically or mentally unable to return to the workforce when they're released, so they wouldn't be provided those documents either. It would take effect on July 1st if adopted, and I'm happy to answer questions.
I think we heard this or similar bill in Judiciary Committee last year. Was that not right? And it was.
Yeah, Mr. Chairman.
Tell us what happened with that.
You did hear a similar bill last year. At one point, I had all this history in front of me and in my brain, but that was, I won't say several sleeps ago because that's not really the case, but but it was a few days ago. I think the proponents have some of the history, but it did get out of committee. I believe it even passed the House. The one thing I know has changed since the last version is that the driver's license provision was moved up into subsection, what is that, A2 instead of A3. So there was a small change that the department requested for this version that is slightly different than last year, but.
That changed the substance?
Potentially. So, I mean, you can see under A2, the Secretary has to make a reasonable effort to provide certain things, and under A3, the Secretary shall provide other things. And I think the idea is, you know, if they're eligible for a driver's license or they need an identification card, the Secretary makes efforts to make that happen, but it may not be in the Secretary's control. Those are issued by another agency. And I don't want to speak too much for the proponents, but I think that was the idea.
Thank you. Are there any questions for the revisor from committee? Seeing none, we'll go on to testimony of proponents. Dr. Chris Fanning, Executive Director, Programs and Risk Reduction of the Kansas Department of Corrections. Welcome to committee, Doctor.
Thank you, Mr. Chairman. Members of the committee, we appreciate the opportunity to stand in favor of House Bill 2228. I'm going to keep my remarks brief because you do have a written testimony in front of you, but I want to touch on just a couple highlights. We do support this bill because it provides that critical bridge for our incarcerated individuals to have a successful reentry back into the community. If you think about trying to go and get a vehicle, get a bank account, do those things in order to get a job, you need these forms of identification. It's also important, I think you've seen some of the statistics before, and it is in the written testimony. 95% of our residents will return to our communities. 33% serve less than a year, 47% serve less than 2 years, and 66% serve less than 5 years. So that is a large number of individuals coming back into our communities. I do want to speak briefly to the comment about other agencies needing to support. I want to point out that Secretary Burkhart and the Kansas Department of Labor has been a great partner for us in an initiative to bring driver's license and ID clinics inside our facilities. This has been something that started in 2019 with some mail-in applications. In 2022, the partnership expanded where we actually have KDOL employees and equipment that's brought into each one of our facilities so people can actually have in their hand their driver's license or their ID. I also want to touch briefly on the initiatives that we have. We want to ensure that all of our release plans are approved at all levels. That includes internally within our unit team, within our parole review board, within victim services, as well as outside with our parole services. We want to ensure that individuals are able to meet with these groups 2 weeks prior to release. We have explored models in other states, and we've actually been invited to sit in on some of these, and they're very successful, and we'd like to model that as well. We also are identifying those current components that can be done in less than 16 months. There's always going to be things that need to be completed close to release, right? Transportation plans, program history and progress reports, and financial reconciliation. Currently, there is a restriction of 6 months with our replacement Social Security cards. I'm going to go ahead and speak to that and the challenges. And again, we're going to build on that success in our partnership with the Kansas Department of Labor, building on the success of those driver's license and ID clinics. And again, thank you to Secretary Burkhart and his staff for supporting us in those efforts. Some challenges, of course, timeline restrictions from external entities, specifically Social Security. We are limited to 180 days prior to release before we can get a person's replacement Social Security card, which, of course, this is something that doesn't expire. So this is something that we should be able to do much further into a person's sentence. We also have some challenges making sure that a resident has access to being able to create a really good resume and to do job seeking to the level that they need to be doing it. Currently, our resources limited us because we've got some security issues with software that we are working through. And we also have career navigators that oftentimes have to sit and work one-on-one with each resident in order to develop a resume. And finally, housing. Safe housing is always going to be a challenge, especially for our higher risk folks. So House Bill 2228 benefits not only returning citizens, but also employers, communities, and the overall economy by fostering self-sufficiency and reducing recidivism rates. Thank you, Mr. Chairman, members of the committee. I can stand for questions when appropriate.
Thank you, and we'll take questions at the end of our proponent testimony. Next is Ms. Basaksy. No, you don't. You're listed here, but you're not speaking to this?
Yeah, we're written only for this
Written
one.
only, okay. Jennifer Roth, bids. No Jennifer Roth on WebEx, okay. Chris Stanyard, written only. Yes, I see that. And Shane Hamby again, written only. Okay. All right. So we're ready now for questions for our Dr. Fanning. Okay, we'll come to that. Thank you. Yes, yes, Representative Mosley.
First, thank you, Mr. Chairman, and thank you for your presentation. I live in downtown. I live 2 blocks east of Mass Street in Lawrence, Kansas. So I get a chance to talk to my houseless homies often. And one of the things that comes up constantly is like not having, so when they come out of county, they don't necessarily have the proper identifications to even start their life. How does not having access to the appropriate documentations really impact your ability to fully integrate back into society after you've already served your time?
So thank you, Mr. Chairman, Representative. So if you think about housing in particular, the things that you need in order to sign a rental agreement, you're going to have some form of identification. You're also probably going to have a bank account of some sort in order to put a down payment down. So for housing in particular, that is definitely a barrier. I can go down a list of all of the other elements of reentry as well, but speaking to that specifically.
Are there any other states that provide this type of documentation for individuals leaving the carceral system?
Mr. Chairman, Representative, thank you for that question. I believe that there is, and I can definitely get that information for you. But I do know that as we speak about this nationally, Kansas is one of the forerunners in this effort.
Any other questions from the committee? If not, thank you very much for your testimony and support. There are no opponents and no neutrals as far as I know. Is anyone neutral or opponent in the audience? Seeing none, we will close the hearing on HB 2228 and move on to what's really, I think, a companion bill, HB 2327, which concerns establishing something called a certificate of employability. And I'd like the reviser to advise us on that.
All right. Thank you again, Mr. Chairman. Jason Thompson, Revisor's Office. So House Bill 2327, as you mentioned, establishes procedures and requirements for the Secretary of Corrections to issue a certificate of employability to certain inmates. This one, like the last one, is a new section of law, and it provides that the Secretary, upon release of an inmate from custody, would identify the educational and training history of the inmate, and they would issue a certificate of employability to that inmate if they meet 3 criteria. 1, prior to incarceration or while incarcerated, they earned their high school diploma, their GED, a college degree, certification from a vocational or technical education program, or some similar diploma or degree from a correspondence post-secondary education program. 2, the inmate received no major disciplinary violations during the year immediately preceding release. And 3, the inmate received the necessary score on a job skills assessment test that the Secretary will determine they use to assess that. If the Secretary issues one of these certificates of employability, they are required to revoke that certificate from an inmate if that inmate is then convicted of a felony after release from custody. If an inmate has one of these certificates revoked, they can appeal that decision to the Secretary, and the Secretary is not liable for any damages based on their decision to issue, deny, revoke, or any of that, a certificate of employability. Finally, the Secretary is required to make all inmates aware of the opportunity to obtain one of these certificates, and inmates are not allowed to represent that they have a certificate of employability, knowing that that statement is false. If they do that and violate the provisions of that paragraph, it's a Class B non-person misdemeanor to sort of falsely represent that you have one of these certificates when you do not. I said finally, there's actually page 2 that I just got to. In a proceeding involving a claim against an employer for negligent hiring, one of these certificates of liability could be at issue in those proceedings. you could say that you relied on one of these certificates as a defense to one of these claims, and a certificate of employability could be admitted as evidence of the employer's due care in hiring the inmate. So these certificates would have a little bit of relevance to those negligent hiring actions if they're filed. Then the last piece is prior to January 15th of next year and each January 15th thereafter, the Secretary will report to the Governor, the Speaker, and the President of the Senate about the number of certificates that they issued in the preceding year and the rate of recidivism among inmates who received those certificates. So you'll be able to track a little bit of the data. It would take effect on July 1st if adopted, and I'll stand for questions.
Any questions for the revisor on this bill? Yes, Representative Mosley.
Sorry to be that person today. My question for you is, will there be any other demographics tracked when like that report is given out to make sure that there's like equitability across the board so that there's like the representation makes sense for people who are receiving this certificate?
Mr. Chairman and Representative, it's a valid question. The only thing that's in the bill is that they have to report on the number of certificates and the rate of recidivism. So anything in addition to that would be allowed, but it would be up to the Secretary to decide what to track and what to report beyond those two items that are required. So I don't know if they'll be able to tell you that they could
I would
track
like to
that.
talk to you after this about what an amendment looks like in this committee. Thank you.
Fair enough.
Representative Carmichael.
Thank you, Mr. Chair. While I certainly agree with the premise and the plan here, I do have a question about the impact. And if I look at the bottom of page 1 and the top of page 2, I see in a proceeding involving a claim against an employer for negligent hiring, sub 1, having relied on a certificate of employability issued pursuant to this section may be a defense to such claim. What does it mean when it says it's a defense? Is it an absolute defense? Is it get out of jail free card for a negligent employer? Is it just evidence that will be admitted, or do you know?
Mr. Chairman, Representative, it's a good question. The language is what you said. It may be a defense to such claim, and it may be admitted as evidence. I almost would say you didn't need to say those things, all right? Those are true statements, right? As a former practicing attorney yourself, you know that what can be admitted as evidence is a question in every case. And so I think maybe they're just trying to put a little validity on these and give a little push to get these admitted, but I don't know that it necessarily would sway a court, right? They're still weighing the rules of evidence. They're still deciding whether something is admissible, whether it goes to the matter at hand, right? Relevance, all of those issues in the civil, and I don't know that this changes any of that necessarily.
Okay. I appreciate that insight. I look forward to hearing from the proponents. Maybe they can address that during their testimony, of course.
Sure. Any other questions from the Committee for the Revisor? Seeing none, we'll move on then to the sole proponent. On WebEx, I understand. David Morgan from the Government Affairs at Reason Foundation. You're saying he's not there? Okay. Has he been there as far as you know? No. Okay. I do know that my office assistant had some communications with him, and he was intending to be here by WebEx. We'll wait. I think in the meantime, Jason, you going back to the was it the bill that you said you did have some history on? Well, maybe we can go back to that. The ID bill, yes.
Sure. Thank you, Mr. Chairman. So, yeah, this is in regard to the previous bill, House Bill 2228. Is that the right one?
Yes, it's 2228. Yes.
The previous hearing, 2228. Too many bill numbers, right? It's going to get worse. The House bill in 2024 was 2522, if you want to look up your voting record, but I'll save you looking up your voting record and just tell you that it did pass out of the Committee on Corrections and Juvenile Justice, and then it passed the House 120 to 0. So if you were here, you didn't vote against it. Then the House Committee on Corrections and Juvenile Justice decided to put the contents of that bill in Senate Bill 419. So sub for Senate Bill 419 also passed the House 122 to 0. So you likely voted for it twice if you were here. But then in conference, that content was removed in favor of a different provision. So it did not become law.
Thank you. Yes, is Mr. Morgan on yet? Not? Okay, then we will close the hearing. There's no opponents, I don't believe, no neutral. So we'll close the hearing. Yeah. That's this fellow Morgan. I mean, he's with reason. That's somebody else. Okay, well, we also have written testimony from Goodwill Industries. Chris Danier. Is he or she here or what? Yes. Well, okay. This is, it's from reason, it's a different person. You didn't get that? Okay. Okay, if you could do that quickly. From this one, yeah. Okay. Yeah. Okay. Yeah. Go ahead. Just a minute. I could have everybody's attention. Representative Schlingensieben has a question for the revisor, I believe, on this bill.
Jason, I was reading in the testimony from the Kansas State Board of Indigent Defense Services. They say, as drafted, the bill excludes people who are physically or mentally, unable to return to the workforce or released to the custody of another jurisdiction. These exclusions are problematic. First, people need identification for more than just employment reasons. They need it to apply for and receive services and benefits, get housing, enter certain spaces, get transportation, etc. Also, who makes the determination of whether someone is unable to return to the workforce? What if a person is destitute after release and must work to get by? They won't have identification documents because they were excluded by the statute. So I guess my question is, can we draw up some kind of amendment that covers this as well? Or is this encroach on the substance not only of this bill, but perhaps other legislation that already exists in that regard?
If you can answer that, Jason.
Thank you, Mr. Chairman. Jason Thompson, Revisor's Office again. So the provision you're talking about, again, this is in the prior bill, 2228. It's just at the very bottom of page 1, there are a couple of things that the section does not apply to. One of them is if the secretary is releasing them to the custody of another jurisdiction on a warrant or detainer, they don't have to issue these documents or help them get the documents. The other is the physically or mentally unable to return to the workforce. And it is as determined by the secretary. So it would be the secretary's sole.
I'd ask that the committee listen to Jason and not talk among themselves.
So the provision you were asking about was just, it's exclusively determined by the secretary, and if you wanted to remove it, it's a fairly simple strike of a few lines. And yeah, we can certainly prepare that if that's what the committee would like.
Thank you. I think what we're going to do now is move on to working one or two of the bills that we were scheduled to work yesterday. HB 2215, which is a public-private partnership bill asked for by the Department of Corrections. And do I have a motion? Please do.
I move.
This is HB number 2215. Does the committee wish to discuss the bill? We need a second. Representative Ressman. See, yeah, discussion. Yes, Representative Carmichael.
Thank you, Mr. Chair. I appreciate the committee hearing my thoughts here. They're not full-throated opposition to this bill, but I have continuing concerns. I'm concerned about religious institutions establishing an untoward presence or more of a presence in our state correctional system than perhaps I believe would be appropriate. When you have a religious organization contributing to the building of the state penitentiary, some places they build chapels. I think religion is a wonderful thing. I encourage people to follow their religious tenets, study the good book, as I know Representative Schlegelnsiepen has. He's referred me to scripture in the past that I found very helpful. But I'm just concerned about public-private partnerships in the context of what has gone on in the past. And I think we too closely mix church and state, and that not by intent, but by impact, we make religious belief, if not a prerequisite to release, certainly a substantial factor. And for that reason, I will not be voting in support of this bill. And I wish I knew more about who the people are bringing the money and what specifically is going to be done with it. But as you'll recall, the representative DOC was unable to provide that information for confidentiality reasons. So that's the reason for my no vote. And I'm not terribly solid on it. Somebody can convince me by the time it goes to the floor. Thank you.
Representative Smith.
Thank you, Mr. Chair. Mr. Chair, can I ask, I got a lot of respect for the previous representative. I just was wondering why he feels like this might happen. I would just like to know your insight on that.
We're in a discussion mode here, so yes, you can have colloquy with other committee members.
Sure. I can point to, and it's now with somewhat vague recollection, but programs at the Department of Corrections where religious organizations establish a special program. People who participate in the special program have received special benefits, and I understand that that is one of the things that is evaluated when we start talking about paroling people out of prison. And I see a puzzled look on Ms. King's face, but I know that historically we've had those types of programs at KSP, and I've had a serious concern that, quite frankly, we were pressuring people to subscribe to the Christian faith when they may have come to the penitentiary with a different faith. And I'm sorry, I'm a big separation of church and state guy, so I understand that not all of you may agree with that, but that's the gravamen of my concern.
Representative Smith, any further questions or comments?
Again, Representative, I got a lot of respect for you. I agree with separation of church and state. I guess I've never had the experiences where I had to worry about that. And you must really have had some experience that really has affected your thought on that.
I've only been in the state penitentiary once in the past 30 or 40 years. I did spend time in law school there, trying to help people who live there, and I was aware of programs then, and I think some have been touted as great success stories. And so, you know, I'll be where I'm at on this probably, and I'm not really trying to suggest that others, they can make their own decisions about that, but I think we have to guard against our state penitentiaries becoming a place where we may over-proselytize people, and they may feel like that they're under pressure to subscribe to religious beliefs of a sponsoring organization. And I hope I'm wrong. I'll be happy to talk to DOC about it in the future. Thank you.
Any other discussion? Yes. Yeah, sure, Representative Smith.
I have a friend that is not the same faith as I am, and he goes to the county jail, and these inmates choose whether they come down and listen to him or not. They're not forced to. They choose to come down. And I was told that he does a better job of helping people than our society that is trying to help these people. So he's a positive, and he is doing what you said, Mr. Carmichael, so thank you.
If I might, just one more remark. My deceased mother-in-law participated in jail ministry at the Sedgwick County Jail for many, many, many years. And I'm not here saying that those are necessarily bad programs, but I think we have to guard against establishment of religion in the penitentiary. Thank you.
Any other comments? I would just make one comment. The bill that we're actually discussing it does not change anything in this law with respect to faith-based organizations. The only thing it does is increase the contribution of the government to these private-public partnerships. So your objection, seems to be to the underlying law rather than to the actual bill. Any other comments?
You're absolutely correct, Mr. Chair. I don't want to increase the influence by increasing the contributions, because with money comes influence. And so it was a different match, and now I think it's a greater match. Maybe I have it backwards.
Yeah, it's going to be.
I do have it backwards.
It's going to be increasing the public contribution.
I do have it backwards.
Okay, thank you.
My concern still yet remains. Thank you.
Yes, Representative Schlingensieben.
So I moved this for sake of discussion. What exactly are we voting on here? This is kind of I mean, I've read the bill, but what is the nature of the public-private partnership that makes this bill necessary?
It's my understanding from the testimony, if I recall, that the private entities that wanted to contribute wanted the government to contribute a larger percentage to the partnership. That's why this has gone from shall not exceed 25% to 50%. Representative Ressman.
Thank you, Mr. Chair. I think we heard testimony that the Department of Corrections had a consultant that conducted a fundraising campaign, and that's when it was determined that potential donors would like to see a 50-50 match, so everybody would have skin in the game.
Yeah, and just referring back to the Department of Corrections and their testimony too. So for the purpose of financing and constructing an education or workforce training center, which would provide a broader range of adult education, career and technical education, college degree, and career readiness programs.
Thank you. All right. You moved.
So I did move, but I mean, one more question. So, I mean, does this have anything to do with religious organizations necessarily? I mean, I see in subsection F that there is reference to it, but is this a matter that has to do with fundraising for any? In other words, we put up 50%, but it could be any private entity. It doesn't have to be a faith-based community. It could be anything else. Am I right? I mean,
that's my understanding. Yes. We could ask the reviser about that question. Right.
Mr. Chairman, I would just say that this match is part of the entire public-private entity partnership. So there's a group of statutes that deal with public-private partnerships for construction projects, and this would make it a 50-50 match for any of those projects, which includes some faith-based organization participation, but others that are not. It is all of them.
That answer your question?
I guess it does. I mean, I guess I don't understand why faith-based is even mentioned in the bill if all it does is allow public-private partnerships. I guess why is it even in the bill? I mean, I think it sounds like a very sound fundraising principle, but I don't understand, if we're not excluding faith-based organizations, why are we specifically mentioning them? So I guess that's my question.
Once again, that's really not the bill, that's the statute that exists. The bill itself is only changing see that, that's the only change in the bill.
So what am I reading here?
You're reading the statute that's being revised or amended.
My apologies.
Okay, all right?
Yeah.
Thank you.
All right, sorry.
Yeah. Any further questions or comments, discussion? Representative Schlingensief, I believe you moved, or you want to close?
I'll close. I move that the committee recommend HB 2215 favorably for passage.
You've heard the motion. All in favor, say aye. Aye. Same against? Okay. Aye. You're right. I got confused. So, okay, all right. All right, so that bill 2215 is passed out favorably or passed to the floor. Since we're over time, I'm going to now turn again to our hearing on the employability certificate, and I understand our conferee, Mr. Morgan, is on WebEx, and I'd ask that he speak to us, please.
Yes, thank you, Mr. Chair, Chair Lewis, and members of the committee. My name is David Morgan, and I'm the Governmental Affairs Associate at Reason Foundation. Thank you for the opportunity to provide comments on House Bill 2327. House Bill 2327 aims to improve employment opportunities for eligible inmates who are released from ks.gov custody by directly addressing the practical concerns of potential employers. House Bill 2327 does not withhold information about an individual's conviction record from employers, and it does not provide the formerly incarcerated with an undue advantage in the labor market. Rather, the legislation creates a certificate of employability that may serve as evidence of due care in hiring in cases where an employer is accused of negligent hiring. Similar reforms have been successfully implemented in other states and are supported by peer review research. Thank you for your time and consideration.
Thank you, Mr. Morgan. Are there any questions for the proponent? Representative Carmichael.
Mr. Morgan, unfortunately, and it's probably through my fault, I don't have a copy of your written testimony, so if I'm repetitious, I apologize. First, did you say you're with the Reason Foundation?
Yes, Reason Foundation, correct.
What is the Reason Foundation? Where are you out of? What do you do?
Yes, we're a nonprofit think tank, and we have several public policy priorities, one being criminal justice reform. We have two locations, one in Washington, D.C., one in Los Angeles, California. We are more of a libertarian organization that believes in freedom. And one of our policy priorities, amongst others, is criminal justice reform. And that's why we're here in support of House Bill 2327.
Thank you. I think you're probably supported by some folks from my town. But my second question is, you talked about this being something that would facilitate employers hiring previously incarcerated individuals, particularly in a litigious environment or people sometimes are sued for negligent hiring practices. And at the bottom of page 1, at line 34 of the bill, and going over into page 2, it says, in a proceeding involving a claim against an employer for negligent hiring, going to page 2 at line 1, having relied on a certificate of employability issued pursuant to this section may be a defense to such claim. What does it mean for this certificate and reliance to be a defense to the claim? Is it absolute defense, one factor to possibly be considered? Help me understand what the legal significance of that is.
Yes, well, the overall goal is to make sure that no employer is held liable, so that there can't be any, because we don't want to put employers in peril or at risk for giving someone an opportunity. This is just merely saying that, hey, this person has an opportunity, that they have shown some due care while incarcerated. And if an employer gives the person an opportunity to be gainfully employed, no one can circle around and say, hey, or they can't be held liable for anything that might occur in a negative manner by hiring this particular individual.
Mr. Chair, I know the hour's late, but I do need one more question, and that is, so you interpret this language as constituting an absolute defense for an employer who may be alleged to have negligently hired a formerly incarcerated person. So long as they have this certificate, they can't be sued for hiring that person, no matter what the job is or what other facts they might know. Is that correct?
That is.
Okay, thank you.
Any other questions from the committee for this proponent? No? Seeing none, I think we'll thank Mr. Morgan for the WebEx presentation. I don't believe there's any other proponents, opponents coming, or neutrals. And we'll therefore close the hearing on, what's the bill number? What's the bill number we're on?
2327.
2327, thank you. Okay, I think because the hour is late, we will adjourn for the day. We'll come back to the bill that we were on to be worked. I'm looking at the research assistant. She wants to tell me something. So as you heard on the floor today, we're not meeting, we're not in session, we're not having committee meeting tomorrow. So I think the better course is to move what we were going to do tomorrow to Thursday and what we were going to do Thursday to Friday. And I'm cautiously optimistic that if we work hard Thursday and Friday, Monday we'll need to work, but it won't be crazy. But who knows how that's all going to shake out. So thank you. We are adjourned.